Good afternoon. My name is Melanie Bates, and I'm a special counsel for the American Bar Association section of Civil Rights and Social Justice. I'm also the owner of Melanie Bates Consulting, LLC, a Washington, D.C. based strategic policy and communications firm with an overall focus on criminal justice reform. The section of Civil Rights and Social Justice is very excited to present today's chair chat featuring two very distinguished professors, Juan Thomas and Amos Jones. Welcome, professors. The CRSJ Chair Chat was established by our very own past chair, Juan Thomas, and is designed to bring together legal scholars, advocates, thought leaders, and activists committed to fighting for social justice, protecting our democracy, and upholding the rule of law, and to share strategies for tackling the existing and emerging civil rights issues facing our country. I would like to give a special thank you to Madam Chair Lacy Durham for the opportunity to serve as today's guest host. All of the chair chats are housed on our section's YouTube page. Please share the links with your friends and colleagues. We're actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. As an overview of today's topic, Amplifying the Black American Lawyer, I'd like to provide a little bit of historical context and background. So historically, as we know, Blacks were excluded from every aspect of the legal field. This exclusion forced Blacks to develop their own schools, organizations, and other creative strategies to advance in the profession. Blacks were also prevented from taking bar examinations. Unless the Black lawyer had the opportunity to work as an apprentice with a white lawyer, they were unable to move forward. Blacks were preventing from joining the American Bar Association, so they established the National Bar Association in 1925. There were approximately 1,200 Black lawyers in the country at the time, none of whom qualified for membership in the ABA simply because of the color of their skin. We need more Black lawyers. There are more than 1.3 million lawyers in the United States. Black lawyers, however, were just 4.8% of the profession in 2013 and only rose to 5% in 2023. We need lawyers who can see themselves in the people they are prosecuting and representing. We need lawyers with lived experience who know what it feels like to exist in a legal system that discounts you simply because of the color of your skin. We need lawyers who have empathy and compassion for both the victims and the accused. Access to the courthouse doors is one of the most important ways to effectuate change. Therefore, we must ensure that we do all we can to ensure Blacks have the resources necessary to enter the legal profession. This Chair Chat episode is designed to shine a spotlight on the tremendous significance of Black American lawyers, especially now during Black History Month and every day. With that, I'd like to officially introduce our esteemed guests, Professors Juan Thomas and Professor Amos Jones. Juan Thomas is the founder and principal of the Thomas Law Group, and his practice includes the following specialties: real estate planning, labor and employment, and family law. In addition, Professor Thomas provides counseling and training to firm clients in areas involving personnel, collective bargaining, and business development matters. In August 2023, he was elected, Secretary of the National Conference of Bar Presidents, which is a national association of lawyer leaders whose mission is to provide high-quality programming and leadership development training for members of the legal community. Professor Thomas is currently a member of the American Bar Association's Board of Governors. He served as our chair of the section of Civil Rights and Social Justice during 2022 and 2023. As chair, he convened the first ever Economic Justice Summit, where he brought together policymakers, experts, and community leaders to develop policy solutions to address issues of economic inequality. As mentioned, Professor Thomas launched and hosted a weekly podcast named The Chair Chat, where he interviewed leaders in numerous fields to address civil rights and social justice issues. He is a past member of the ABA's Africa Law Initiative Council and the Nominating Committee. Professor Thomas is the second vice president of the Illinois Bar Foundation, and he previously served on the Illinois State Bar Association Board of Governors. He is also a past co-chair of the board of directors of the American Constitution Society Chicago chapter and serves as the general counsel to the Morehouse College National Alumni Association. Professor Thomas served as the 75th president of the National Bar Association from 2017 to 2018. During his term as president, the NBA co-founded the National Commission for Voter Justice to address voter suppression across the country while advancing electoral reform and civic engagement. Professor Thomas received the American Bar Association's 2024 Spirit of Excellence Award for his efforts to promote a more racially and ethnically diverse legal profession. A graduate of Morehouse College, Professor Thomas received his Juris Doctorate and Master's in Educational Policy degree from the University of Illinois at Urbana. And an ordained Baptist minister, Professor Thomas also holds a Master of Arts in Religious Studies from the University of Chicago Divinity School and a Doctor in Ministry degree in Preaching from the Chicago Theological Seminary. In addition to his professional and civic involvement, Professor Thomas and his wife, Angela, are proud members of the Cathedral of Grace St. John AME in Aurora, where he serves as a minister for social justice. Please join me in giving me a virtual round of applause for Professor Thomas. Thank you for being here today.
Thank you, Melanie.
Our next esteemed panelist, Professor Amos Jones, is a top 100 super lawyer, American attorney who practiced with Brian Cave in Washington, D.C. for 3 years before joining the Legal Academy in North Carolina for 7, earning unanimous promotion to the rank of Associate Professor of Law in 2015 at Baptist-affiliated Campbell University in Raleigh. In 2006 to 2007, Professor Jones was a Fulbright postgraduate scholar at the University of Melbourne, Australia, and in fall 2015 was academic visitor to the Faculty of Law at the University of Oxford, United Kingdom. He was awarded the Lifetime Achievement Award by the America's Top 100 Attorneys Rating Organization in July 2018, and in May 2019 was honored with the Albert M. Marquise Lifetime Achievement Award by the publishers of Who's Who in America at just 41 years old. Professor Jones established the Amos Jones Law Firm in August 2010 to practice in those areas in which he was theorizing as he entered the Legal Academy full-time. His specialties include civil rights, contracts, especially in employment, constitutional law, particularly freedom of religion, discrimination, mass corporate industries, and the Foreign Agents Registration Act of 1938, and political forecasting. A noted appellate attorney, Professor Jones has won key contracts in civil rights disputes and employment litigation before major courts of appeals, all on behalf of wrongfully terminated employees. Professor Jones has operated and grown Amos Jones Law Firm since its founding in August 2010 in Washington, D.C., during the week in which he embarked upon 7 years as a full-time law professor in North Carolina, starting as a visiting assistant professor of constitutional law at North Carolina Central University School of Law in Durham. He then joined Campbell University's Norman Adrian Wiggins School of Law in Raleigh, where he became an award-winning teacher and designed the most popular elective course in the school, History of the Black American Lawyer. Even though the school's enrollment was only 3% African American, the course in spring 2015 had swelled to 78 students, 70 of them Caucasian. As vice chair of faculty recruitment in his second year, Professor Jones, then the only Black on the law faculty, brokered the hiring of the first ever Black woman onto the tenure track faculty at the school. 7 years later, that professor would become the first tenured African-American woman in the history of Campbell University at large. Campbell was founded in 1887. A National Merit Scholar, Professor Jones earned his Bachelor of Arts, cum laude, in political science from Emory University in 2000, minoring in African American studies. After several years as a full-time journalist, he earned his Master of Science from Columbia University's Graduate School of Journalism in 2003, where he organized the Columbia Journalism Guild. He then earned his Juris Doctor in 2006 from the Harvard Law School. Please join me in giving a virtual round of applause to Professor Amos Jones. Thank you all both for being here today, and thank you to our viewers for your patience and hearing me talk. I know we are ready to hear from our illustrious panelists. So let's start off. Again, the theme here is the history of the Black American lawyer in light of Black History Month. So to each of you, What should our viewers know about the history of the Black American lawyer?
Well, thank you for those kind words. And Professor Thomas, it's an honor to be on a panel with you and your great work that spans the institutions of this great country and indeed the world. The African American lawyer is a paradoxical figure because, after all, most Blacks arrived here by virtue of slavery. Slave ships on the Middle Passage, um, changed languages and oppression for hundreds of years, and it was illegal to teach slaves how to read and write. And that's all that lawyers do. You read and you write and you analyze, and you're called to outsmart and outwit the adversary day by day. And that's criminal for most of American history. Thank God the American Bar Association reversed course because it barred all Black lawyers until the 1940s because they were Black. Before that, a Time magazine article from 1938 covering the National Bar Association convention reported there were 1,200 attorneys who were Black in the United States. About 250 of them were right here in Washington, D.C., as late as 1940. So there were 7 or 8 Black women judges during World War II serving mostly in Massachusetts and New York and Washington, D.C., the usual suspects. So the Black American lawyer is a special creature of an environment where there was no equal protection for Blacks until the 14th Amendment. And then it lasted a few years and it was abrogated until 1954 nominally. So that's the milieu in which these warriors for their people in an unfashionable setting, because you couldn't make a lot of money as a Black lawyer until recently, relatively speaking, where they went out to make crooked ways straight. So it was a deeply spiritual endeavor when you were against these principalities, where sometimes the white judge wouldn't even let you talk in court. The bailiff had more status than the lawyer. So here we are in a whole new world.
It's an honor to be with you as well. Your work in this space is extraordinary, and I'm proud to be with you and be associated with one of your proteges, our host, moderator for this afternoon, Melanie E, who's a tremendous leader in our profession and in the American Bar Association. I echo all of your sentiments regarding the history of the Black lawyer, and I would put it in this context, particularly in this moment that we're in right now. We have to recognize that we are dealing with the great-grandchildren of those who opposed Black lawyers and women to be members of the American Bar Association. We're living in a time where the grandchildren of those who opposed the Civil Rights Act and the Voting Rights Act and the Public Accommodations Act of the Civil Rights era left the Democratic Party to become Republicans. And Lyndon Baines Johnson put it best when he said that we have lost a generation of Southern voters because of these acts, paraphrasing. We are living in a time where the children of those who were raised by those who supported the Bakke decision and resisted affirmative action are now in power. And they have an agenda to ban our history, to rewrite the narrative of America, and to go back to a time where our story would not be told. And they are in power now. And so the history of the Black lawyer must be told. And Professor Jones talked about not only as a legal discipline, but a spiritual discipline as well. It was our faith that carried us through that journey, right? It was over troubled waters that got us through. And so it's critically important that law students and young lawyers learn the history of the Black lawyer, because in a real sense, it was the work of the Black lawyer that pushed and challenged America to live up to its promise. Equal justice under the law. It was the black lawyer that challenged and pushed America to live up to its creed. We hold these truths to be self-evident, that all men are created equal. And all of us know when those words were written, all men did not include the three of us. And so the black lawyer, in a real sense, has been pushing America to live up to its promise and to fulfill its promise. And given the assault that we're under today, the work is even more important now. And I'll pause with this comment. We've been using the language of resistance the last several weeks. A colleague of mine pushed back on the word resistance because it implies that we'll one day be overcome. They want to use the word, we are opposed to this effort. We're not just going to resist this effort, we are opposed to it, and we're going to push back and fight back. And the history of the black lawyer teaches us that those who went before us, those shoulders upon which we stand, they did just that.
Thank you, Professor Thomas. Push back and fight back. Thank you, Professor Jones, for laying that foundation in history. And both of you are distinguished professors of the history of the Black American lawyer. As we mentioned, I think all three of us have our books here at our desks. So what can you
This
tell?
is the Bible.
The
Bible.
Bible, yes.
The Bible. The Bible.
Emancipation.
That's right.
What can you tell our viewers about why it's important to have Blacks in the legal profession? At the top, I mentioned the stark disparities there and how important it is for our residents, our people, to have representation that they can see themselves in. But what message do you share with our viewers and your students about why we need to forge on and push forward?
Well, I'll start with this question. Well, I can't say that I'm a proud graduate of Howard University, but I have heard of Charles Hamilton Houston. And he was famous for saying that we are either parasites on society or we're social engineers. He was a mentor to Thurgood Marshall, whose pen I proudly wear in honor of Black history in this conversation today. The Black lawyer has been that social engineer. We've been the conscience of America. We have actually believed in the Declaration of Independence and this whole notion of what we call freedom and justice. We believed in that because we came from a place of enslavement where our station in life did not measure up to the creed of America. And so we said, we believe in freedom too. Frederick Douglass talked about this in his famous speech about the 4th of July. Other heroes and sheroes, again, pushing America to live up to its promise. And so I think what is critically important in this moment is to recognize that the reason why the Black lawyer is so critically important is because we have often had to be the conscience of the nation. And I say also as a minister, in partnership and collaboration, often with the Black church.
And indeed, representation matters. It's still the case that there are experiences largely common to the African American demographic by virtue of our history, culture, which involves religious aspects as well as locational and geographic aspects, and certainly being raced under Jim Crow in many places for much of American history. And so having that kind of understanding that until recently could be assumed, the further away you get from Jim Crow and slavery and the more integrated things become, obviously the less common those experiences. But that's why I want to call on our pioneers when we talk about representation and the why of it. And I just want to say, and we lifted up our Bible, the Emancipation Book by J. Clay Smith, the late former dean of Howard University School of Law. I was so fortunate to get to go to his memorial service in the chapel of Howard Law School just several years ago. And with a great man who gave us an encyclopedia from 1844 to 1944, the making of the Black American lawyer. So I want to lift up three names so that the audience understands back when we were enslaved, largely in our country, under the Constitution, the very first Black American lawyer, by most historians regard that to be Macon Bowling Allen, who passed the bar in Maine in 1844, and well in the antebellum period. The first Black American judge, George Ruffin, who also happened to be the first Black graduate of the Harvard Law School, 1869, graduates from Harvard Law School. 1883, he's appointed a judge in the Boston area, the first Black American judge, and the first Black female lawyer in American history, Charlotte E. Ray, who graduated from Howard University School of Law in 1872. Women, if you thought blacks were, remember, Black men could vote before white women could vote. So to be a female attorney in 1872, she applied to the bar under the name C.E. Ray, so that there wouldn't be, as some was, a trouble at the river, Reverend Professor Thomas, and she passed and specialized in real estate law. But you have to do diplomatic tricks. The lawyer is called to be a diplomat. When my discrimination clients call me and hire me, some of them want to go guns blazing with a lawsuit and to CBS News right away. And I tell them the nuclear bomb doesn't get dropped till after there's a bunch of non-surrendering. Okay, I tell them as bad as it was, FDR had a hotline to Hitler because he had the power to stop the war over in Europe. So as much as as evil as they were in the Third Reich, realistically, they're the ones who can actually stop it voluntarily or to be led to do so. So that's the role of a lawyer. That's why so many of our lawmakers are lawyers. A good lawyer can fight, but can fold. You have to know when to hold them and know when to fold them. So for Black lawyering, when you are a minority, this was not like South Africa, where the apartheid came in the 1950s and Blacks were a majority and were subjugate. They could go do what Mandela did and have guerrilla warfare. That might make sense. African Americans, who are 13%, who aren't allowed to have a gun, you're going to have to work through the pulpit and maybe even a little bit of court in the classroom. They criticize Booker T. Washington, and I think it was the 1895, the Great Compromise speech. And he said, oh, we can be separate and like the fingers on the hand, but we can be a hand. And, you know, they thought he's shucking and jiving. He's selling out the Black people. And the older I got, the more I realized, wait a minute, that was 1895 in Atlanta. The Klan had already come in. Reconstruction was over. Booker T was just being pragmatic. He knew we weren't going to get anywhere. And he secretly developed classical education and funded a bunch of causes. So there's room for both. So that diplomacy, the perspective of the oppressed. I used to tell my students, if women were barred from voting until the 19th Amendment around the 1920-ish, how did they get the constitutional amendment? They had to persuade the men. And the men voted and the women got the vote. It's not fair, but when you are oppressed and subjugated, the magic of having to win people over, like Richard Allen, the founder of the AME Church, he preached so persuasively, his master converted to Christianity. And then when he founded the AME Society, the white Methodists tried to take the building back under the trust clause. And my understanding, Reverend Thomas, is they had their lawyers and stuff, but he said, you know what? Methodism is still good.
That's right.
Our burden as Black people, with our perspective, is again to make these crooked ways straight. And we have taken it on ourselves. We have helped our country through the Civil War to develop we women and all other groups, immigrant groups, all marginalized groups have modeled themselves. And now the world over, in Tiananmen Square in 1989, they were chanting, "We shall overcome." And we know that "we shall overcome" was not just a Martin Luther King, Fred Shuttlesworth motif, but it was a Thurgood Marshall reality. It was a Charles Hamilton Houston reality. And don't forget the good whites. There comes a place in the Black American lawyer. You remember Professor Thomas and Melanie in the material that a white man would have to vouch for you because they were the lawyers. Mm-hmm. So if you wanted to be on the first Black lawyer in any state, it took a white lawyer in the bar to tell them he's okay, he can come. And often those white lawyers risked a lot of social capital, especially in the South, to stand for these brothers, because it was all men pretty much. And so there comes a point in the class with these dramatic, uplifting stories. Again, I had white students largely at Campbell, where we'd just be so inspired of how the white person really fought for the black and the black triumphant American story he was admitted and practiced and whatever. And I would pause and say, never underestimate the power of a good white man. But it's true, there's an obligation. And if your great-grandfather could do that with the Klan knocking at the door, burning the crosses, well, what can you do in the boardroom to have a more perfect union? So I also just want to lift up, because I'm going to lift up something I've never done. There are certain institutions and people who have helped the Black American lawyer in social justice from their purchase. Louis Brandeis was one of them. Louis Brandeis secretly, and now we would say perhaps in an ethically questionable way, was always instructing secretly the civil rights groups like the NAACP and Dr. Charles Emmett in Houston in the methods of how to make that Constitution work. And he said, don't tell anybody till I'm dead. And so if it hadn't been for the very brilliant Justice Brandeis, the first Jewish justice, a founder of the Harvard Law Review, and they say the originator of public interest practice, if it hadn't been for Louis Brandeis from his position, we might not have had Charles Emmett in Houston working so expeditiously. It might have been slower. And I also want to lift up a law firm. I have no connection to this firm, but it's historical. The Paul Weiss law firm in New York has a history of bringing in, before it's fashionable, a string of Black trailblazing, fearless Charles Emmett in Houston type attorneys. Pauli Murray worked there. Bill Coleman worked there. Again, this was before it was fashionable to have Blacks in these high-profile type corporate matters. Reginald Lewis worked there. Did I get Paul Robeson? So you also have a sense of responsibility on the part of the white community who have been the best of this profession, who have understood we must be inclusive and we must support these African-American schools like Howard University School of Law and North Carolina Central School of Law and Southern University Law Center and the Thurgood Marshall Law Center at Texas Southern and University of District of Columbia Law, and I'm leaving one of them out. There, Florida A&M, I think I got them all. All of those historically Black law schools. So I said a lot, but our people in the profession, our people broadly as lawyers, must understand what it takes to bring in these representational realities that animate the law and inform the law and make the law more complete and more true to the constitutional inclusion on which we've insisted since the Declaration of Independence.
Well, can I add one thing to that?
Absolutely.
The reason why this is so important is because Black lawyers need to be equipped, and all lawyers need to be equipped with this history, because it helps inform you how to strategize and advocate in this current moment that we're in. This fight that we're in right now, the attack on DE&I, the false narrative that we need to go back to a merit-based society. We've never been a merit-based society. The attack on all of the progress and gains of the last 50, 60 years. It is not new. There's always been this backlash, this resistance, this, as Dr. King said in his speech, Other America, white backlash against progress, particularly for African Americans. And we need to also be very cognizant of the fact that we are still making history. We have just gotten access to these institutions during our lifetime or our parents' lifetime. Let me give you just this statistic, these facts. I'm teaching this class, History of the Black Lawyer in America, at the University of Illinois in Champaign-Urbana. In Illinois, the first Black female judge elected in my home state was in 1962, when my mother was 11 years old. The Illinois State Bar Association, which I'm a past board member of, elected its first Black president in 2016, 9 years ago. He's now a judge in Will County, which is a suburban county here in the Chicago area. We've only had one woman of color who currently has ever served as state bar president in Illinois. The Illinois State Bar is 148 years old. This past week, I have a colleague who reminded me she was the first Black woman elected circuit court judge in DuPage County, Illinois, which is another suburban county. We are still making first. We are still knocking down doors. And this is true all across the country. New Mexico just elected its first Black female to be their state bar president just this past year. And so this whole narrative that we have, we need, what's what I'm looking for? Somehow we're getting ahead because of our color. It's not true. It's false. And what I say to my Caucasian colleagues who are not always allies, I remind them, you have an affirmative action policy too. It's been called the Good Old Boy Network. And that's how you've gotten ahead most of your career. And so I think we need to push back on this false narrative of a merit-based society. Not that merit's not important, but we need to figure out who are the true objective evaluators of merit and make sure that we're all judged by the same standards and that all biases are removed. But we also need to recognize that we're still in the struggle for opportunity and gains and access. Even in corporate law, we're still less than 3 to 5% of partners in major law firms. So even though DE&I has been important, some would argue it hasn't really been successful because the numbers are still drastically very low in our profession in many key areas. And so we have tremendous work to do. And that's why it's important that we are armed not just with the knowledge of the law, but the knowledge of the history so that we are better equipped to fight this current battle.
Excellent. Excellent, both of you. Thank you so much for providing this wealth of knowledge. I'm fired up and ready to go to do what we need to do to keep moving forward, to keep elevating Black lawyers and Black law students. So as we close here today, what are your specific call to actions for the American Bar Association specifically and the community at large to help support our people in the profession?
Thank you, Melanie, and it's been a pleasure. The American Bar Association and our profession at large in this country must engage in a very critical self-examination. And we must do our own thinking as a profession. All of what we've talked about, information and education matter. I want to give a shout out to Professor Kenneth Mack, who's probably the most eminent, hands down, the most eminent historian of Black American lawyers living. Up at Harvard Law School, he wrote a great book, Representing the Race, the Creation of the Civil Rights Lawyer. People like him and his work, and the late Lonnie Guinier and the late Charles Ogletree, we must look at what the law is doing or not doing through our personnel, starting with the judges who superintend the process. We need to look at disciplinary counsel offices who increasingly are being exposed for all kinds of bias against lawyers who help the most vulnerable people. We perhaps need to continue to focus on policing, but understand that the people imposing sentences are actually judges, not police officers. And those of us who practice law know that judges make errors all the time, and they get reversed all the time. And perhaps court reform is more properly situated at trial courts and not the Supreme Court, where nobody poor gets to go anyway, unless you're linked in with a handful of advocates who have a lock on that court and the moneyed interests who are in the boutique. That is the Supreme Court of the United States. The federal trial court judge has far more power, and people don't have the money to appeal. And it's funny that we don't have 3 judge panels like Section 5 preclearance panels that we decided should have 3 judges due to racism in the bench. I think we should have 3 judge trial panels because justice is not that blind. It's deeply subjective. That's why we have more than 1 judge on appeal. If justice were that blind, we would only have 1 Supreme Court justice, wouldn't we? Justice Roberts, the umpire. But it's not blind. That's why we have 9 of them. And thank God, by the way, 40% of cases at the Supreme Court are unanimous. which tells me there are some really ignorant judges making stupid mistakes to get reversed 9. And how dumb. So like, we really need to do self-examination and expand the pie. And so I'm a big fan of converting all trial courts to 3-judge panels to diversify perspective and everything else, and to stop some of the unfair and silly biasness and just lack of thought that we see coming out of these courts. That's the major reason we have mass incarceration. It's pathetic, but we're afraid to do that. And one reason I occupy an independent space and work for my own firm is so that I can be free to expose and tell the truth, and hopefully our children and our children's children will live in a better world where we don't waste time on bias and stupidity from the lowest level of justice. We need to look internally, and the ABA needs to be on the forefront of court reform that matters, and that's not a political tail wagging the dog up at the Supreme Court, where most people never will wind up anyway.
Thank you, Professor Jones.
I would say 2 things. One, lawyers need to, in this moment, stand up and support their oath and uphold the rule of law. Irrespective of your partisan affiliation, lawyers support and uphold the rule of law. And let me say on the record, if you are willing to start telling your clients to ignore court orders and suggest that judges don't interpret the law and interpret the Constitution and ignore their rulings, I respectfully ask you to resign from all bar associations where you are a member or a leader, and please turn in your law license. You are no longer worthy to be a member of this privileged profession. We can debate public policy all day long. We can disagree on tax rates and immigration reform and climate change, but we will not debate the rules that we all swore an oath to uphold. And I want to applaud my colleagues and our president of the ABA, Bill Bay, who has stood up and made it very clear. The ABA will support the rule of law. Secondly, I think we need to re-examine in this moment civic education and law school education. Professor Jones and I have taught, and I'm currently teaching a course on the history of the Black lawyer in America. I'm suggesting that this type of course be offered and be put in curriculum as a required course for law schools all across the country. It's critically important that we know our history. And we're creating a generation, because of our progress, we are a victim of our own progress. We are creating a generation of lawyers who aren't connected to the civil rights struggle, who didn't grow up in Jim Crow segregation. And so they didn't live this. I was born in 1970, 2 years after the death of Dr. King, 6 years after the Civil Rights Act was passed, 5 years after the Voting Rights Act was passed. My grandparents and parents lived through that, and I was connected to it through their lived experiences. My mother went to a segregated school in Mississippi, even though Brown was passed or was ruled on in 54-55. Class of 1969, Yazoo City, Mississippi, still had segregated schools because the South resisted integrating public schools. And so my children and grandchildren and my colleagues' children and grandchildren are even further removed from that. We have to tell those stories. And I'm afraid that they may come up in an era now that the the gains are being pulled back, and they don't have the history of their grandparents and their great-grandparents. They may feel as though they are facing something that no man has ever met, and that is not the case. And so for them to see it through, they must be equipped with the history. And so I want the ABA and all of us in this space to advocate, push, and strategize around how do we get this type of course curriculum in our law schools, in our colleges, so that our future leaders are equipped with this knowledge. Because, yes, you need to have the actual Bible if you are a person of faith in one hand, but you need to have this in the other hand, emancipation. And I'll also say this, and I might be putting some work on myself, but I want to put this out as a concept and a thought. This book ends in 1944. We probably need to write the sequel. And a group of scholars and thought leaders need to think about 1944 to 2024. And the history of that era of Black lawyers needs to be recorded. I think Professor Jones would be an excellent author for such a
And you can be at least the editor. And I must say, if that's the Bible, then this is the devotional. This is the one, the women's perspectives that J.
right.
Clay Smith edited, Rebels in Law Voices. And this is an essay series that came, and I think it might have gone a little beyond 1944, but those are essays. So I do want to give a shout out to the book devoted to the experience of the African-American women in the profession that J. Clay Smith edited.
That's right.
Thank you both, gentlemen. We are at time. I want to say that both of you are remarkable. Excellent, excellent material, remarks, thoughts, and insight today. As I said, I'm fired up and ready to go. I know our audiences are as well. Thank you for being trailblazers. Thank you for leading the way. Thank you for lifting up this critical history during Black History Month and every day. We are ready. We're ready to follow in your footsteps and move forward with every charge that you have shared today with us. And so round of applause again, virtual round of applause for both of you. Thank you so much for being an inspiration.
Thank you for having us.
You're welcome. Thank you to each of you for watching today's Chair Chat. We'd like to express our sincere gratitude again to our esteemed guests, Professor Jones and Professor Thomas. And the section of Civil Rights and Social Justice provides free webinars and resources like this for legal professionals and advocates nationwide. We hope this program helps you in your work. And if you can, please consider joining and becoming an active member of the American Bar Association. You may do so at americanbar.org/CRSJ. Happy Black History Month. Bye-bye.